let's first of all look at what a judge does in regard to making findings of fact. We can have a look at what findings of fact involve, what finding on law points involved, and how judges deal with discretions. Now, the admissibility issue isn't often one that comes to the fore. As a general rule, it's very seldom that inadmissible evidence is used. But that's got to be dealt with. You need to be alive to the fact that you might have an admissibility problem. But credibility and reliability are the two critical findings which are made. Now, how do you decide that? It's old hat now that the distance between the witness's eyes and whether or not he or she's got a scar down the side of the face doesn't impress the judge one way or another about whether the chap's reliable or giving credible evidence. But these decisions are made always on probability. And you need to be keenly aware that when a judge is asked for a credibility finding, ultimately the analysis is going to be in relation to probability. In exactly the same way when you prepare a witness who you know is going to be faced with a credibility challenge, you have to assess how to present that witness's evidence in order to be able to face up to that challenge. Many witnesses tell the truth, but in such a way that it is unconvincing. You need to take account of that. Sometimes the truth has an air of improbability about it. You have to see to what extent you can find evidence that corroborates that in order to eliminate the quite legitimate question of how surely that could not have happened. Very often witnesses understand something to have happened because of their worldview of what is taking place, but it doesn't actually accord with reality. As counsel, we're aware of those, and you need to adapt in order to cope with it. At the other end of the consumption of your brief, the judge is grappling with the same issues and needs to be fed what is required in order to make a finding of fact. So you need to bear in mind the interrelationship between credibility, reliability, and probability in all of those things. The onus, which we know has no role in application matters, also has very seldom a role to play in trial matters, contrary to what you might read in the books. I can't think of a single case where a matter was decided because of the onus. I'm sure they do happen, but they're very often the question of the onus is completely ignored. It's true in criminal matters, it's more likely to arise, but that's in a quite different upfront way where clearly you're in a position to say, well, beyond a reasonable doubt hasn't been established. But in civil matters, very seldom arises. Then on law points, what is the judge looking for there? What's he faced with? Is it a novel law point, in which case he or she can't really grapple with it unless all the case law relevant is presented? You need to assemble that. Is it just a question of an application of a legal principle? In which case, what the judge is looking for is help in the analysis of how the facts match up with that legal principle. That's often more simple than we think, provided it's done in a coherent fashion. There's no point taking 7 pages in your argument in order to develop that when you can do it in one paragraph. Just can't sustain the concentration span long enough for that kind of thing. And then the more difficult one is the interpretation. You've got a statute or a common law principle that needs interpretation to cope with a new set of facts or a particularly oddball situation. You need to be able to rationally formulate the rival views. Remember this, the judge, if he's properly impartial, ought not to care who wins. So the judge is not leaning one way or another to find something. Just wants a rational, justifiable, intellectually honest answer. And if you can provide an analysis that enables that decision to be made, then obviously it's an advantage to all. But the big uncertainty is when it comes to discretions, because discretions are always value judgments. And the moral values of society, no less of the judge, him or herself, obviously come into play there. And there are particular areas where these discretions are critical, where there aren't any right or wrong answers. Family issues, who gets the kids? How often do you see them? In Rule 43, how much money does she need in order to live decently? These things are as much guesswork as anything else. Let's not kid ourselves. All you've got to do is try and make an honest answer. That's what the judge is looking for help. In criminal matters with sentencing, it's probably the most fraught area of discretion. Quoting every judgment in Greek Roland West and adding in all the glosses in Henry Harvey does not help in getting a judge to decide what the sentence is. One of the biggest mistakes made, once one sees it in criminal appeals, is that the counsel who come into those appeals think that flooding the judge with case law, which is a cut and paste from last week's heads, instead of actually grappling with the facts, will help. Usually the law doesn't help at all. Principles are so trite. What you really need is a proper analysis of the facts. That's what the judge is looking for in sentencing matters. There are other things where moral values come in, but largely the debate's been resolved by the courts. And I mention them simply in order to alert you to what can evolve into a doctrine that no longer becomes controversial. Evictions and foreclosures are the two big examples, where the court has spoken on all those issues, and the moral values are now well established. They seldom present a problem of principle. The only question, once again, comes is, do I evict these people? How long do I give them to go out? Under what conditions? What do I tell the municipality? Or in the foreclosures, is there a prospect of this mortgage bond being revived? Is there a prospect of another form of execution settling this debt, etc.? One has to be alive to those issues when you're asking a judge to exercise a discretion. So those are the working conditions and the types of cases